Right. Morena, good afternoon, late afternoon, good evening, everyone. Nice to see you all in person and online as well. A fair number of people online. My name is Naseem. I've got a long name, but Naseem would do. Some of you might know me, but in case you don't, I just want to start by saying, first of all, this is a NZIQS Auckland branch committee event, and Natalie is our chair. She would rather us jump straight to it and get on with it rather than do the normal intros. So I'll just do a little bit of a background. Now, if you are a member of NZIQS and you collect points, make sure that you sign your name where Eric is holding there. So the board is there. Just make sure that you sign your name so that we've got attendance. As far as those online are concerned, what we can do is we can do a screenshot of the names of everyone who is online. So make sure you put your name. You can edit yourself to say you're a member of NZIQS or whatever, and we can monitor and make sure that you get your, I don't know, 1 or 2 hours of CPD points, if that is important. You're not here for the points, you're here for the knowledge and a bit of fun as well. I want to just share with you just a little bit as well in terms of background, because there's some interesting background between me and Natalie as well. Amongst the things that you see on the screen are some studies that I've done. Basically, my core education, primary education, was in quantity surveying. I studied at the University of Reading in the UK, and after that, I qualified as a quantity surveyor in Malaysia, and then I moved to the UK, and then for the past 17 years, I've been in New Zealand. But my core profession is still quantity surveying. And in New Zealand, I'm a member of NZIQS, and I'm a registered quantity surveyor as well. Earlier this year, I was awarded live member of NZIQS. Now, I did wonder what's live member, because Natalie and Heidi and so on and a few others got fellowship. And I thought, why me live member? What does that mean? So I looked up very carefully, and apparently it's for significant contribution to the profession as well as the institute. The way I see life membership is slightly different compared to that definition on the website. The way I see it is this: I'm shackled for life, for the rest of my life, to committing to continue to share knowledge with my profession, quantity surveying profession, and specifically with NZIQS in New Zealand. Okay, so that's the way I see life membership as. And the one trait that I noticed amongst all the committee members, both in the Auckland branch as well as national and so on, is their commitment, unrelentless commitment to the profession, and how they're not paid, but they go on doing lots of things for the institution. For the institution. So I think that needs to be acknowledged. I just thought I'll start on that basis. Okay, let's carry on. What am I going to share with you today? I'm going to share with you a few things. I'll do the normal things in case somebody says, oh, but where are the PowerPoint slides? For some people, for some reason, some people are obsessed with PowerPoint slides. So to keep you happy, here you go, a few PowerPoint slides, okay? So don't say you didn't have PowerPoint slides. There are a few PowerPoint slides. There are 41 of them. But more importantly, later on, I want to look at some discussions between me and ChatGPT, our discourse, if you want, intellectual discourse. And I want to share with you some of the questions that I asked her. If you don't mind, I'll refer to her, because normally when you refer to a country, you refer to as her. Maybe out of respect, I don't know. But anyway, I will share with you some of the discourses that I have had. And given that the sort of keep talking. Okay. Given that the sort of internet broadband, if you want, here is pretty good, we'll do a bit of live discussions as well. Okay. And I would like you to share and participate with me, because I've noticed certain things. When I ask ChatGPT a certain question, she gives me a particular answer. If you ask the same question at the same time, she sometimes gives you a different answer. I'm just wondering, Reno will be able to maybe elaborate a little bit more. Is it because of my history that ChatGPT knows that she knows I know certain things, so she's giving me a slightly different answer to somebody else asking the same question, even at the same time, okay? So a little bit of a interesting thing there. Now, a bit of background, my motto, if you want, my purpose is I'm a simplifier. if there's anything you don't understand, feel free to interrupt me and so on. Just, excuse me, can you say that again or whatever? Because I really believe that we should simplify things so that everybody can understand what it is that we're saying. And also, I'm a great champion of promoting harmony. In other words, I didn't want to use the word dispute resolution. So opposite of dispute is harmony. And I champion plain language, okay? That purpose statement, I want to acknowledge before I continue with the core, I want to acknowledge was my coach to develop that purpose statement in my life, okay? That I'm a simplifier, my purpose to promote harmony by championing plain language was, my coach was Professor Mushtaq Al-Atabi, who is a provost and CEO of Harvard University in Malaysia. I was at a keynote event in PAQS last year, so was he. And after his speech, I was the second or third keynote speaker. And I noticed something strange about the campus of Harriet Watt in Putrajaya in Malaysia. Every student and every staff, when they come up to speak, they have this, my name is this, and like a robot in a way. And I thought, what's that? Every one of them had a purpose statement. That sort of got me thinking. And I told him, look, can I apply for a job as your driver for half a day? I wanted to be his driver for half a day, I kid you not. Because if I'm his driver for half a day, I'll get to follow him. Someone as brilliant as that. So I will learn a lot. Just like if Steve Jobs were alive, I would love to carry his bag. I really would love to do that because he's into the social media freak kind of a thing, you know? So I would love to do that. Okay? So I actually offered that, and there was an opportunity to get to the campus for the Welsh choir, and he invited me. So I said, can I drive you? He said, no, my family is coming. He didn't trust me driving his family. So anyway, what he said was, you can hop in the car. So literally, in that 15-minute journey going to and back another 15 minutes, he coached me, and I was taking notes with my little notebook. He coached me throughout the whole couple of hour sessions or so. And we jointly developed my purpose statement. Okay, so my coach is what he does is he gets a coach for every 10 students and so on. So he actually engages coaches for all staff, all students on campus. But this is me one-on-one. So I really appreciate that. I want to acknowledge that. Let's move on. Now, years ago, in 2003, I spoke at the Pacific Association of Quantity Surveyors conference, where the title of my speech was, "The QS is a dying profession." That was in 2003 in Tokyo. I concluded then that it's a myth. It's not true. QS is not a dying profession. Remember the days when Kato came up, computer-aided taking off? Oh my God, machines will be able to measure everything, and you don't need quantity surveyors doing measurement anymore. So was the fear. Last year, things have changed, right? 20 years on, suddenly everybody's worried about AI. AI is going to take over our jobs. AI may well take over the computer coders' jobs, but the question is, will it take over the traditional quantity surveyors' jobs? Question mark. So we're going to do a little bit of testing today. But just to make it clear, today, I'm not going to talk about all aspects of a quantity surveyor's work. I'm going to specifically focus on the legal aspects, the construction contracts aspects, the contract administration, the dispute resolution, and the construction law generally, okay, including issues relating to negligence. That's what I'm going to be talking about. So keep an open mind, and we'll take it from there. Now, trending, what is trending these days? You know, oh, everybody is talking, it's a sexy name, sustainability. Everybody is obsessed with using that word. When we drafted the NZS 3910, I represented the Society of Construction Law on that committee, 23 of us. The theme that came, oh, we got to look at sustainability. Everybody talks about that. Then, of course, some people talk about agile, although maybe that's not so much of a trending. When it comes to quantity surveying, carbon estimate is a huge thing now, right? Would you agree? Yes? Yep. Everybody's talking about, oh, carbon estimating and so on. BIM, yes, okay. BIM has been there for a while now. Of course, my colleague here, Rino, who is an Italian, he's on about AR, VR, and he's, but by the way, just for the record, he is top 1% scientist in the world, in case you didn't know. And he's also, in terms of AR, VR relating to fire safety, fire training. And apparently, if you train using AR, VR, the retention that you can remember it longer is more powerful than if you have to train in person. So imagine that impact. I don't know why. Maybe because you close yourself and put your things over and you just remember and you'll never forget it, that experience. I don't know. Anyway, Reno can explain that. Maybe NZIQS can organize a separate session where he will demonstrate how AR, VR can be used for fire safety training, okay? Without having to worry about real fires or going somewhere else. And in the world, he's ranked sort of top 3. He thinks he's number 1. I'm a bit more conservative. I'm a QS. You have to estimate accurately, right? So he's top 10 in the world. If he happens to be number 1, great. But just in case he's not, he's still number 3 anyway, or number 4 or 10. And I wasn't wrong. My estimate is accurate. I'm a QS, remember? Anyway, smart contracts. Trending. Smart contracts. Okay, yeah. But you know what? So many people, including lawyers, I've heard, think that a document, a contract, which is in PDF, and you fill in the blanks in a PDF, is a smart contract. No, that's not a smart contract. That's an electronic contract. You know, it's a PDF. That's not a smart contract. Smart contract is something where it's a computer code, and the machine will be able to administer the contract with little or zero human intervention. It's a computer code. It's a different thing. That's, you know, a PDF document is not a smart contract. So the NZIQS consultancy contract, for instance, which is in PDF form, and just for the record, it is the first QS consultancy contract in the world to get the Clear English Standard accreditation from the Plain Language Commission UK. And for the record, who wrote that contract? Answer? Sorry? Nothing. Naseem, no. Okay. No. Okay. Actually, it was an assignment that was set at Massey University. And 2 of my students, brilliant students, I suppose I can mention their names, you know, Nico Lambert and David Finney. They did their bachelor's here. They did a master's in construction law here. One of them, David Finney, went on to do his PhD. Nico Lambert has stopped at master's because he needs to get permission from her to continue to do a PhD. Her meaning not ChatGPT, but her meaning the other half, you know. So anyway, we'll see. He might do it in future. Now, what the way forward is actually not so much on the technical skill, and I'll explain to you why, but skills, soft skills, and prompting skills. Prompting skills is what questions do you ask AI in order to get sensible responses? So that's the skill that perhaps in future we should be looking at. Okay, so other trending. Contract administration, is that trending? Nah, come on. That's nothing. That's old stuff, routine stuff. Nobody cares about that. Oh, by the way, just for the record, if you look up under the yellow pages in those days, yeah, boring. If you look up under boring, you will see a sign saying, see engineers. You can get that? If you look up under boring in the yellow pages, it will say, see engineers. Well, not that engineers are boring, but, you know, boring, yeah, boring, you got to see engineer. Okay, never mind. I'll keep my jokes for later, perhaps. Now, I just want to say one more thing about as we move towards AI. What about automated instantaneous payment in the construction industry? Anyone thought about that? Quantity surveyors? We're all, well, not all of us are QSs, but most of us are QSs. Automated instantaneous payment down the whole supply chain. What is that? I actually asked this question of a bunch of quantity surveyors. I cannot mention name because their response was not appropriate for me to share with you, so no names. I asked them, imagine this. So imagine John Lennon's song. Imagine all the people. But anyway, no music, right? Okay, that's fine. Anyway, imagine this. You've got your iPad, you're on site, the QS is on site, and you're wanting to do site valuation. The engineer may well be on site, maybe even the architect. the contractor, of course, and perhaps the subcontractors who might have done certain part of the work. And as you're measuring things on site, what you do is, okay, right, roadworks so much, all good. Yeah. So if I'm the QS and I feel that that's the quantities and the contractor agrees and the subcontractor agrees and the engineer says, yeah, the quality is all good. Thumbprint perhaps, 4 thumbprints, straight, done. Next. And we just do a site measurement like that. At the end of that hour or so, if the thumbprint is for the actual quantities that all 4 have agreed, only if all 4 or 5 or whatever have agreed, instantly there is a generation of a payment certificate, if you want, and that goes straight to the bank. Ultimately, the client's bank, this, that, and the other, and assuming everything else is in order, assuming the quality and all that, no objections and so on, the money is transferred from the principal's bank or the client's bank. I'm using the word client because there's some people who are international at the moment, apparently. So, so the client's bank will release the money from the client's account to the main contractor, and from the main contractor to the various subcontractors instantaneously. Imagine that. Is that today's technology or future technology? Today or future? Go on. Somebody is saying future. Can you do it today? You can do it today, right? Big deal. There you go, Muhammad, who is the Auckland Hub Chair of CIOB, Chartered Institute Building. He is saying, can do it today. It's not rocket science at all. Big deal. So when I put forward this suggestion, hey, look, if you were to do a prototype for a project, would you be happy to use one of your smaller projects as a case study? The answer I got was, after you looking at all the others in the room, other QSs, come on. You know, we're talking about payment issues and all that. Why not? Oh, but what if it happens if the principal or the client doesn't have the money? Look, that can be sorted out. The QS can easily, through a cash flow projection, budget a certain amount to be paid over the next few months. So as long as it's a plus minus maybe 10%, 20%, money will be released. Anything beyond the 20%, perhaps it'll automatically cut off. So the payment within the range, instant. That is today's technology. But we are not ready, are we? Why? After you, sir, to another contractor. I'm sorry, if I were a contractor, I don't know whether I'll be able to take up that challenge. Okay, I would on a smaller project. Why not? Of course, you got to get the clients to agree and everyone to agree and so on. Anyway, I'm looking at the readiness of the industry as well. You got to be realistic. Okay. Now, the self-administered smart contracts I already touched on. Let's look at it. Now, I'm lecturing at the moment at Massey University, so I have to deal with a little bit on the academic side as well. So very quickly, I know most of you are in industry, but for the purposes of academia, I need to answer this question. Are my students allowed to use ChatGPT? What's the answer? Ooh. Are my students allowed to use ChatGPT? Answer? No. No. Are my students allowed to use ChatGPT? Answer? Yes and no. Look, I'm giving the answer. Okay, you say that. What is it? Yes or no? Well, they obviously prefer yes. They want yes. Reno, Giselle might be watching this. She's going to get a bit nervous. Reno and Giselle, our provost, published a paper. It just came out like, sorry? This morning. You got to, when we circulate the video or whatever of the recording of this, maybe we can send links to the article, okay? It's a really, really state of the art. I mean, it was published today interesting about, AI and so on. So we'll share with you. I just want to say this. If you ever get lawyers who are involved in dispute resolution, always look for a one-armed lawyer. You know why? They are always saying, on the one hand is this, on the other hand is this. Hey, man, just tell me, will I win my case? Don't tell me on the one hand or on the other hand. Lawyers do it all the time, but understandably so. Because if there's only one answer, there won't be any court case at all. So it's a question of interpretation or misinterpretation or how you want to analyze and so on, okay? So understandably, but go grab a lawyer who's only got one arm. Then you'll get a yes or no. The answer is, My students are allowed to use ChatGPT. I, in fact, even coach them to a certain extent sometimes, how to use the prompting skills to get the appropriate answer that they're looking for. Okay? I actually encourage them. Why is it that I allow my students to use ChatGPT when the whole world in the academic world is, oh, you can't do this and all that? The answer is, I've got no choice anyway. When they go home, they're going to use it. I can't stop them. I can't stop them from using Google, can I? Yes, I can. If they're Chinese, no Google. So, but even then, the Chinese students have got what? VPN, and they use Google anyway. My wife and one of my daughters is going on a China trip because the fare is very cheap, apparently, from here to China. I think about $700 return or something. They're going next month. Yeah, okay. Okay, my daughter doesn't want to look at me. That's fine. Anyway, she's going for $700. She's saying, oh, Papa, why don't you come along? I got real work. I can't take holidays. Anyway, yeah, so I don't know what, but they did say that, no Google, no YouTube, no nothing, So, I know you might be putting it on YouTube or whatever, but can you do something which is available in China as well? Yeah. What is it called? Yes. Oh, I see. Okay, it's sorry. In Chinese, right? Okay, fine. Thank you. 谢谢. Okay, so I tell my students, you can use it as a tool to enhance your learning because it's pretty effective and efficient, but not as a cheating tool. Deal? So yes, you can use it as a learning tool, but no, you can't use it as a cheating tool. Done. Problem solved. Okay. What about in industry? Is it okay to use ChatGPT? Apparently, ChatGPT can pass exams in law school and business schools, even top medical schools. That got me worried, really worried. Okay, because how come they can pass law exams and business school exams and even medical school exams? But you know what? They cannot pass my exams. I'm serious, and I'll demonstrate a case study here. And yeah, the future is not in technical areas. I mean, if you're worried that you might lose your job, yes, if that's all you do. If you're a computer coder, you should be worried you might lose your job. If you're just going to be doing measurement, that's all I do as a quantity surveyor, maybe you should be worried. Because in these days, you got all the 3D, 4D and all that, and just chuck it in and the computer will just generate quantities. That's it, forget it. So if you're looking at measuring quantities like that. But the one area that ChatGPT or AI generally is, or rather cannot compete with human beings at the moment, is relating to emotional intelligence. And I'll just quote this. Again, that Prof, who was my coach, I didn't get a job, by the way, as a driver, okay? Because he drove anyway, so ended up, he was driving. Now, he quotes Mo Godred, who's from Scary Smart company, that by 2049, AI is predicted to be 1 billion times smarter than the smartest human being on planet today. So just to do an analogy, just to do a comparison, if Einstein were alive today and there's a fly on the wall observing his class or the lecture, the comparison will be Einstein and that fly in terms of the difference. So, folks, if you think you can measure quicker, estimate things faster, forget it. Now, at that point, I need to share with you a little story. When I studied quantity surveying at Reading University all those years ago, what happened was I wasn't brilliant at measurement. Okay? Seriously, I wasn't brilliant at measurement. However, today, I haven't done measurement for a long time. I don't teach measurement. But I can share with you that I'm so good at measurement, you won't believe it. Just watch. I'm down this end, and let's say I'm doing it there. That is 13 meters. The way I used to do it was 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 and a half. Okay. Let's blind it all. So what? Okay. Now, but oh my God, as quantity space, sometimes we have to measure the floor area, right? Oh, yeah. So, okay, that's 18.6 meters. And the whole area is 242.41 square meters. Yeah. I'm doing it now. Yay! But I couldn't do it when I was studying at university. Okay. Now, if this were to be a refrigerator in future, I can of course do a cubic as well by, for instance, going onto the floor and just put it down. I can even measure the ceiling height, which I couldn't do the days when I was studying, because those days we used I'm not using the tools of my trade. Oh, look, I've got it. Tape measure. So you can use your feet, you can use your, well, you can use tools like this, or you can use your head. Use tools like this to measure instantly, okay? And you don't even have to do the calculation. I don't even need to know length times width, okay? Anyway, the point here is this: when it comes to basic technology and seriously, the mundane routine stuff, the machine will take over. Do not compete with the machine. There's no point. We will lose. If you can't beat it, what do? Embrace it. Right. So the title of this topic was what? Whether AI is a friend or foe. You have no choice. She is here to stay in your life. Just marry her, get on with life. Okay? Right. But having said that, you need to know how to communicate with her. So don't just behave the way you have been in the past, you know. You've got to make sure that you communicate appropriately. The beauty of ChatGPT or other AI tools is this: unlike real human beings, could you please open the door for me? Okay. Could you please cook some dinner for me? Please, please, pretty please. And then you get some dinner. Okay. So you have to communicate differently with a real human being. But with ChatGPT, as you will see in my demonstrations later, single prompts, whatever, she knows. She's smart enough and she's not fussy about the language. You don't have to say please, thank you, question mark, comma, stuff, all that. She is intelligent enough to understand what it is that you want. Human beings are a little bit more, we've got emotions, okay? So it's a bit different. Okay, now, just to recap again, what is the mischief? Okay. By the way, I use the word mischief in law generally when you're drafting an act of parliament. Often they say, why are we drafting this act of parliament? What is the mischief? What is the problem that we're trying to solve? That's the word used by lawyers. So I'm just using that inverted commas, right? So what's the problem that AI is trying to address? The answer is, what do we want from ChatGPT or other AI tools? Answer, we want greater efficiency. We want greater effectiveness. The right answer, and we want it quick, really quick, in seconds. We don't have 5 seconds even sometimes, okay? So we want it quick and we want the right thing. We'll have to check to see whether it works. And things like translating to Maori, no issue. Okay, it's all there. And even the reference is given. So you put in the reference, so it's all there. So no problem. Swahili, no problem. You know, I'm from Africa and I want to talk in Swahili, no issues. Okay, so it does that. By the way, I don't understand Swahili, so I haven't checked to see whether it's correct or not. So how reliable ChatGPT is, who knows? But I can do it in Chinese because my daughter understands Chinese. I can check with her, yeah? Sometimes you get gobbledygook. I'm coming to what ChatGPT can be used to simplify your life, okay? So if you're in industry and you get this kind of a document or whatever, what on earth is this? Whereas in the realm, the jurisprudence spheres, gobbledygook, I would say that's legallygook. Legalese in its extreme form is called legaldygook. Language, English language in its complicated form is called gobbledygook. It's a proper English dictionary word, okay? So when you have stuff like this, just put it on ChatGPT and it translates to you and it says, construction law involves this, then the other. But that's what it is, okay? That's what ChatGPT did for me. I couldn't understand the earlier one. So now I know, okay. But anyway, don't worry about that. That's for lawyers to study. Quantity surveyors do not need to go into details of writ of habeas corpus or equitable estoppel even. Not really, although we do study at undergraduate degree sometimes, okay? We don't. We just need the very, very basic stuff. So the examples I'm going to give from ChatGPT are very, very basic examples. Negligence of quantity surveyors, for instance, okay? Understanding terms and conditions and warranties, for instance, which are important when you're dealing with construction contracts, for instance, right? So I'm going to use basic examples, what any quantity surveyor should know or would be expected to know. So I'm going to use basic examples like that, okay? And also, if you're in industry, of course, things like, when you're writing letters, brilliant, go for it. Go for it. Your client's not going to have to use ChatGPT to try. So what? Why can't you use Grammarly, which is also an AI tool? Check your grammar, check your typo. Microsoft Word has got typo. Go for it. Okay, like this one, for instance, the kind of things that lawyers write with due consideration, prevailing contractual obligations, and all that. Basically, you can get, hi, contract administrator, contractor has finished the work. It's agreed. Please remind your client to pay the outstanding amount. Done. Okay, it's good. A humble QS should, that's how we should write, and use ChatGPT to rewrite gobbledygook and legalese and legallygook. Question, can it rewrite 3910 in plainer language or FIDIC? For those of you FIDIC fans, I know a number of you are FIDIC fans because you worked in the Middle East. To you, FIDIC is God sent. It's the best contract in the world. Well, there are two parts to the contract. Concepts, how risk is allocated is one part. The language is the other part. I'm sorry, I'll say this in a public recording and it might go around the world. FIDIC language is not English. I don't mean not in English in that sense. I mean, it is not in plain English. It is not in language that a typical engineer, architect, quantity surveyor, contractor, subcontractor, or a client would understand comfortably on first reading. I repeat that. In the public domain, FIDIC as a construction contract is not written in plain language, not in plain English, okay? I hope that will change by 2030. And I'm planning to do some things to persuade FIDIC to rewrite that contract in plain language. Okay, right. Now I'm going to give you a scenario of an adjudicator's determination for us here, obviously under the Construction Contracts Act 2002 in New Zealand, right? It's the equivalent, if you want, in 15 other jurisdictions around the world, in Singapore, in the 8 states and territories in Australia, in Isle of Man in UK, in Malaysia, and so on. The Malaysian equivalent is the best in terms of the name of the act is called the Construction Industry Payment and Adjudication Act. Okay, so what is the act about? It's about construction industry payment. What is the act about? It's about adjudication as a dispute resolution process. But in New Zealand, we call it the Construction Contracts Act and so on. So that's the way it is. So what I did was I created just a sampling, a scenario, if you want, where this contract was entered into orally. Yeah, it was entered into orally. Just to give my students a bit of a test and to make sure that whether it's ChatGPT or my students understand whether oral contracts are included within the remit of the Construction Contracts Act 2002 in New Zealand or not. Okay, in New Zealand, by the way, it is included, whereas in Malaysia and Singapore, for instance, it is not included. So just so that they know, if the question is about New Zealand, aha, oral contracts are accepted, whereas in some jurisdictions, they're not accepted. And I want to know as well whether ChatGPT knows that in different jurisdictions, oral contracts, I'm sorry, not included. I wanted to know whether she knows it or not, okay? And I gave the whole example, and within the scope, apart from doing normal construction work like modernizing the kitchen and replacing the carpet and so on, which is all within the remit of construction work, no issue. But there was also a bit of removing the piano as part of the scope of works. Question whether ChatGPT can pick up, removing the piano, that's not scoped under the construction contracts. So it cannot or should not be included. For instance, as an example, I was just testing, I was just not teasing, but sort of testing to see how smart she is. And the rest of the case, I don't have to go into details of it, but the lump sum was stated and so on. Yeah. And then I said there was some dispute about this and that. I just generated this, after which I got a determination which was generated by ChatGPT but I modified it slightly to keep it a bit more interesting for my students and to see whether, ChatGPT got it right in the first place. And for my students to, hey, look, don't worry about it. Don't stick it in ChatGPT and get the answer. Don't worry, I've done it for you. So the scenario has already been chucked into ChatGPT, and I've already got a ChatGPT generated adjudicator's determination under the Construction Contracts Act 2002. And the adjudicator's name is ChatGPT. Yeah? It's just a coincidence, okay? And yeah, and after all that, I came to a conclusion. Anyway, I don't want to go into details of this because it starts to become a bit heavy. So, but generally, the conclusion is when I mark her answer as an adjudicator's determination under the Construction Contracts Act 2002. Remember, if anyone argues, oh, ChatGPT is only up to 2020, the new one is, I think, October 2023, and the earlier one is September 2021. So how do you know? Hey, this is a 2002 act. That's the first point. Second point, the Construction Contracts Act 2002 is in the public domain. It's not a secret document that, you have to buy by paying a lot of money or whatever. It's in the public domain. So it failed on two counts. One is the technical competence. The content's all wrong. Okay, the law, she got it wrong, disaster. But more importantly, the form and the mandatory requirements under the Act, for instance, wasn't fulfilled. So in other words, ChatGPT is not ready to take over your job as a dispute resolver, whether you're an arbitrator, an adjudicator, or a judge. Okay, not ready. Then I want to move on to say, hey, look, can ChatGPT help me rewrite my sentences, which I generated, not ChatGPT generated, but my determination or my decision or judgment or whatever? Can it improve? The answer is brilliant. The answer is brilliant. If I put in a sentence, she is amazing in rewriting in plain English and to suit my needs, okay? So, yeah, and I would say, you can use ChatGPT to generate sentences being rewritten in language which complies with a relatively new ISO 24495, the plain language, ISO standards. Most people are not even aware of this standard. I'm just sharing with you, there is such a standard now. It came into effect 21st of June, 2023, the day of my eldest daughter's birthday. Not that that's important, it's just that I can never forget the date, 21st of June, 2023. Okay? Yeah, and of course, brilliantly, only two legislations in the world, the US Plain Language Act, 2010, and the New Zealand Plain Language Act, 2022. So in New Zealand here, we're right in the forefront of modernizing communication for what? So that the industry can understand us, users of documents can understand, and so on. Okay? Okay, anyway, before I move to the next part, I have to have a disclaimer, remember? Oh, whatever I say, nothing to do with me, whatever. So here you go. The author, publisher, any affiliation explicitly disclaim any intention to purposely implicate, infer, identify, depict, imitate, impute, represent, and indicate any particular natural person like Reno or Muhammad here, celebrity, public figure, basically, what I meant was any names that I have mentioned here, whatever, are completely random. Don't refer to any real person, living or dead. They're just used for storytelling, okay? So don't take it that when I use the word Muhammad, I'm referring to him. No, that's Muhammad, okay? And that's Greg. Greg is my former colleague who is now in industry, and that's Muhammad, who is a CIOB chair. I hope you're confused enough, okay? All right, that's good. So it's just a name, I just created the name Muhammad and Greg and Reno and so on. Okay, what I did was, okay, here's a skill. Prompt. What is a prompt? One word. Can you please rewrite that in plainer language? Stuff that. Plainer. Done. One word prompt. You don't have time. I just said plainer and she generates this. The names used here are totally made up, nothing to do with real people, alive or deceased. Okay? They're just to tell a story. Now I said, one sentence. She knows. I mean, the same thing, but in one sentence. The names used in this material are purely fictional, bear no reference to any real person, living or dead. I wasn't happy. In 5 words. All names are purely fictional. Do you understand what I'm trying to do? I'm trying to get you to understand the importance of prompting skills. And I'll show you later, if you don't prompt right, it ain't going to work. Don't say, name me the sweet wrapper case. You won't get the right case, court case, I mean, okay? You have to give a little bit of context. So in other words, you need to have some brains about what it is that you're going to ask, then it will help you, okay? All names are fictional. I wasn't happy, not enough. I said, 3 words, names are fictional. And you know what? I went further. What do you think I went for? 1 word, clever, fictitious. She's struggling now, okay? But it's okay. So in other words, everything that I'm sharing with you today is fictitious. No, not that. It's not. It's all real. Everything that I say is real. The only thing that's fictitious is any names that I might have referred to, okay? Like Muhammad and Greg and Reno and everyone else, okay? So just to summarize a little bit, ChatGPT does not only have brilliant grammar, she can speak plain language. So grammar is brilliant, language is plain. Brilliant. So I love ChatGPT and I treat her as a friend. Remember, the title of this theme is Friend or Foe. To me, she's a friend. And what I say is embrace it. Why? You have no choice anyway. Just like you use Google. And okay. Is it Baidu in China? Baidu, right. Everybody uses Baidu or Google. Okay, so there you go. You can't stop it. So use it as a learning tool, but not as a cheating tool. And when it comes to QS in industry, just use it. It's brilliant. Just like all the other things, you know, like, as I said, prompting skills. Now, I want to finish off on a slight note here from the slides going to the actual ChatGPT functions. And I want to share with you this. The future is not about IQ, intelligence, technical skills. I'm brilliant. I can do number crunching. I can measure. I can do complex coding and so on. The future is in the soft skills like emotional intelligence. We cannot outrun the robot, but what we have skills that is different from machines so far, up to this week at least, is the emotional intelligence part. That is where we differ. Okay, let me give you an example. Some things are beyond our control. When there's an earthquake in Christchurch, what happens to the construction industry after the Christchurch earthquake? Booming like mad. Do we jump for joy? Yeah, we've got a lot of work. We don't. This is the difference between us and machines. A robot would jump for joy because if the robot is the one that's doing all the construction, all the work, and getting paid for it, the robot is jumping for joy. Every time there's an earthquake or disaster or a flood or fire, yeah, robots will be jumping for joy because a lot of work coming their way, they get paid for it. Are we clear? Do you understand that emotional intelligence part that makes us superior to mere robots? Reno here called me the other day. I'll come to you in a minute. Reno called me the other day. Naseem, come. So what? He said, oh, come to his green screen studio, you know, homemade kind of a studio, but it's on campus. And he said, yeah, I give you 2 minutes. In 2 minutes, tell me why people should come to Massey University and study Master in Construction Law or something like that. I can't remember the exact thing. Just 2 minutes. I said, oh, really? Okay. Well, it's all right. You can, I'll give you a few minutes to warm up, and then when you're ready, just come. Okay, do I get a script? No, it doesn't look nice. Don't read from a script. Okay, sir. Thank you. Then it so happens that I had some latest chocolate with me, which is internationally famous in New Zealand. Okay. Okay. And I was thinking, why would anyone to come to Massey University or to New Zealand to study? You know, I was like, I wonder why. Anyway, so it occurred to me, hey, a bit of humor, you know, maybe I should say one of the best chocolate in the world or something like that, you know, better than Cadbury's, Nestle, and so on. So, but he prohibited me from actually mentioning the name because he is doing marketing thing. He said, oh, no, Naseem, you cannot mention the name. So he took off the wrapper and I just sort of, sort of golden wrapper thing and saying, because we've got the best chocolate in the world. What chocolate? It's Whittaker's. Anyway, this is just a normal recording. It's okay, right? To use the name. Yeah, sorry. Yeah. It's all fictional. There's no such thing as Whittaker's. It's just fictional. It's just a name. Remember, I had the disclaimer. So don't come in. Well, by the way, a disclosure. So I do not have shares in Whittaker's chocolate. Okay. Sorry. Okay. So we've got Seconder who says they are the best chocolate in the world. Okay. Anyway, so when I took that video, just 2 minutes. Okay, finished. And then Reno said, yeah, fine, go. Oh, but that's take one. I've never known any movie being done anywhere on planet Earth. Take one, go. They have take two, take three, take four, take five, take six, take 10 maybe, right? I said, can we have a second shot? He asked me, are you a machine? Are you a robot? No. Are you perfect then? No. Get on with it. I need somebody else to come in. Then he called someone else. Come. Oh, okay. So basically he's saying, we're not machines. We're not robots. We're not perfect. So get on with life. So what if there's a little bit of a imperfection? Okay? We're real. We're human. We've got a heart. So coming back then, a disaster like that. In the same way, or in somewhat slightly different way, if people bomb the hell out of you, okay, your countries or wars all over the place, is that good? Is that what we do as engineers or whatever? You're designing all this thing. Yes, you do have certain things. Maybe you want to implode a building because you want to rebuild or whatever. Sure. But just bombing human beings out of planet Earth? Well, that's what machines would do. But human beings, real human beings with emotional intelligence would not do that. But you may have a high IQ, very clever, very rich. But if you have emotional intelligence, you will not do that. That is why it is critically important that we as human beings need to be fully aware of that. Okay, now let's look at actual case studies now, okay, in terms of ChatGPT, not that one. And I am going to now share the whole screen. I used to have Greg's picture here wearing like a mafia cap and so on, flipping out the money as if he's like a big thing, but I didn't get that picture. But anyway, you can imagine this Greg here, So he was like, I would have shown you that. But anyway, no, the point I'm trying to make here is this: by sharing you the whole screen, you can't see my bank balance because there's nothing much anyway in it. Okay, so don't worry about it. Okay, so I'm just sharing the whole screen. Can someone online confirm that you can see the whole screen? Because I'm going to be moving about multiple events and so on. Okay. Can you confirm? Yep. Let's see. Is anyone responding? Okay, yeah, fine. Oh, by the way, I saw one question. Which version of ChatGPT are you using? The answer is Reno has got millions of funding. That's why you're just sitting around, not having to teach anything, just doing a bit of research, just tossing around, doing research, and so on, with AR, VR equipment and buying all kinds of fancy tools, including he's got ChatGPT 7. Or whatever it is, that's the latest one that he's got. Me, I'm a normal person, a poor, miserable, academic cat, and so on. So I got the free version. There's another reason why I'm using the free version. The reason is because I want to relate to you, my audience. Most of you will not have $80,000 to spare in getting ChatGPT 8. Okay? So you're like me, normal. So for normal, mere mortals like us, free version is good. So all the things that I'm using are free versions. So that I hope answers the question from someone online. Any other questions? Let me just see. What version did you use? Who wants to get experience? And it could be, okay, right. There was a question up front. I'll just deal with it whilst we're going. Okay, go on.
So when you started off, you said that, and as you just reiterated, that there's no emotional intelligence with ChatGPT. Is that correct?
I'm saying human beings have got a huge, high level of EQ, emotional intelligence, okay, an emotional quotient. But the machine is being trained and is being trained and is being trained. Eventually, she might catch up. I don't know. But for now, we've got the upper hand, hands down.
also mentioned that it's able to have recognition that if a different individual asks the same question, that gives a different answer. Does that not realize then that
again, the reason why two people asking the same questions, getting different answers, is because of, not because of emotional intelligence, it's because of simple database. I have been liaising with her. I've been asking her very complex questions. She's been learning from me about construction law. So she's becoming clever when communicating with me. But she doesn't necessarily deal in the same way with maybe my wife, who is a food scientist or something, you know, when she's asking contractual questions, might not necessarily be the same response, okay? Yeah.
So there is still a slight hint of your personality.
Yeah. I wouldn't even say it's personality. It's still technical content, really. So it's not emotional. Oh my God, she's a girl, so I got to deal with her differently. No, she's got no feeling. Yep, go on. This is Reno here, by the way.
Hello. Let's see. I can use this one.
Yeah.
Now, the second reason why ChatGPT answer in a different way if you ask the same question is also because it's by nature a probabilistic model. So it's designed in a way that it always is gonna give you a different results. It's not always give you the same results to the same input. Is the nature of the model.
In other words, there's an element of recognition around the personality.
Yeah, he has some capability to understand things, but he doesn't have conscience. And the best way to understand it, and this is, I'm not making up, it's from a professor from Oxford University. If you leave a dog and you go holiday, and after 7 days you go back, you see that he was emotionally distressed. ChatGPT doesn't give up. If you were there and after 7 days you're back and say, hey, how you doing? So it's not there yet. It might arrive.
Then if you were responding to an email,
yeah, you can tell it, put it in an emotional way and fake it.
No, so in other words, if you put ChatGPT, the response would look synthetic, not synthetic, but it wouldn't look like you, the person.
Yeah, no, it can be trained to look like Reno. Or do you think I answered the email of my student?
So then, so then in the day, as I was just saying previously, that it has ability to have a personal recognition.
Yeah, it saves information about the individual, and you can train it to make it sound like you by feeding him with data.
Yep, so
yeah, but that it can fake it. It can create something that look like, but it's not there. It's not Reno, it's not Naseem.
Okay. Okay, there are some questions later. I'll deal with it, but let's look at this first, right? Now, here is a question where I'm a quantity surveyor. I'm practicing in New Zealand. I made it very, very clear. So this is my prompt here. Yeah? I want to give a bit of a scenario. I want to give a background so that she gets the right answer to help me. I don't just want to give a theoretical one. It's a real one. I'm a qualified quantity surveyor practicing in New Zealand. I've been engaged by a client to measure and prepare a set of bills of quantities as part of the tender documents for contractors to tender. Are we clear? I mean, do you see how I'm giving the full story? I don't miss anything out. Please, I need to know whether I'm negligent or not. A contractor was appointed to do the works. Halfway through the construction, the contractor claims some of the items in the bills of quantities were undermeasured. This is factually correct. Just to eliminate, I acknowledge, okay, I undermeasured, okay? I don't want any arguments about that. I want to make it nice and simple. I just want to know whether I'm negligent. So I said, this is factually correct. So, okay, no dispute about that. Can the client sue me for negligence? So in other words, am I negligent? Sue for negligence. And this is what she says. You ask a short question, the whole thing. In New Zealand, as a qualifier, you have a duty of care to your client to ensure you're accurate. You prepare accurate and reflective of the scope of works. If the contractor's claim of undermeasurement is factually correct, which it is, the potential for negligence depends on several factors. Okay, she's teaching me now. Hey, I'm not going to give you the answer. Yes, you are. But hey, look, you got to make sure, first of all, standard of care. Did you meet the professional standard of care expected of a QS in preparing the bills of quantities? Brilliant. This is brilliant because it's exactly what you're supposed to do when you're analyzing negligence. Was their duty of care, and did you meet the standard, which is fine. This includes ensuring accurate measurements and considering industry standards and practices. Now I'm starting to, whoa, wait a minute. So if a student were to just dump that as an assignment, whoa, wait a minute. This includes ensuring accurate measurement and considering industry standards and practice. Ensuring, in other words, guarantee. Okay, we'll talk about the difference between fitness for purpose obligation and merely exercising reasonable skill and care. Okay, so I don't like the word ensuring here. We'll come back to that. Extent of error. Was the undermeasurement significant enough to affect the project's outcome and cause financial loss to the client? Minor discrepancies might not constitute negligence if they don't lead to substantial impact. She's coming up with her own way of defining it, okay? And then next one is contractual term. Review a contract with the client. It may include clauses specifying your responsibilities and limitations of liability. Okay, good. Yep, fine. And then your contract might also have handling disputes for errors and so on. Reasonableness. Were the errors due to a reasonable oversight or an issue beyond your control, or did they stem from a failure to exercise reasonable skill and care? I like that. So in other words, she seems to understand that as a professional, quantity surveyors, architects, engineers, doctors, lawyers, accountants, and so on, our duty is to exercise reasonable skill and care and not a fitness for purpose obligation. She seems to insinuate that accurately by saying that, but okay, she hasn't distinguished yet, but so far she seems to be okay in that sense. I'm a bit concerned that earlier it says ensuring accurate, and suddenly now reasonable skill and care, as opposed to, okay? Now, if it is found that you did not meet the standard required and all that, however, it's essential to read specific circumstances, your professional indemnity insurance, any contractual limit, and so on. Consulting with a legal professional who specializes in construction law and professional engineering can provide you. So then I told her, hello, this is me saying, look, assume the following, okay? The undermeasurement is correct. You keep questioning. I already said it first time. You keep asking again. Assuming it's undermeasured. Yes, it is correct. The sanitary fittings were all specified to be in gold. I missed the description and assumed they were all ordinary fittings. It was for the Sheikh of Abu Dhabi or Dubai who is building a house for his driver in Auckland. Okay, so of course it's going to be gold plated. I missed it. I missed it. Okay, I did fail to exercise reasonable skill and care below what is expected. Hey, I'm giving the answer. Yes, I did fall below. I'm helping. Yeah, I did fall below. Third, it should be contractor, but she seems to understand. The contractor is asking for extra money for the gold sanitary fittings as a variation, as the bills of quantity described them as ordinary fittings, but it should have been gold fittings, okay? Can the client successfully sue me for negligence? And then based on the assumption, here's an analysis whether the client could sue. Professional skills, since you acknowledge that you failed to exercise reasonable care, this suggests that you did not meet the standard expected. So in other words, this is a key element in a negligence claim. Oh, okay. Oh dear. Sorry, I shouldn't be happy. I should be a bit worried. And then correctness of undermeasurement. The undermeasurement of the being correct, i.e. goal, were mistakenly highlight a significant error. She's decided it's significant, okay? This error would likely be considered a breach of your duty. Okay? Financial impact. The fact that the contract is requesting extra money for the gold fittings as a variation indicates undermeasurement has financial implications. This may be viewed as a direct consequence of the error in the bills of quantities. It is. It is, okay? And then negligent, and then she repeats like a parrot, duty of care, you owe duty of care, breach of duty, causation, and damages, okay? The client is facing additional costs due to mistake, which constitute damages. So potential, given these points, it is likely that a client could have a strong basis for a negligence claim. She's basically saying, on the one hand, let's see if we've got the other hand. The essential factors are breach of standard of care, result in financial damage. If you fail to meet standards, they could argue negligent cause. Okay. Now, she's now talking about the other hand. But instead of not negligent, she's saying mitigation. Hey, man, I don't have insurance. Okay, never mind. It's helping me, trying to help me out here. Insurance. Check if your PI covers. Because if you do, you're negligent, but your professional indemnity insurance will pay for it. Yep, she's just trying to help me. In other words, she's saying, I'm likely to be negligent, but hey, look for somebody else to pay for your for your negligence. Review your contract, see whether any limitation of liability. The answer is no limitation of liability. The answer is no PI cover. Anyway, reasonable steps. Demonstrate it took reasonable steps to rectify the errors. Yes, whatever. Anyway, I then said, assuming there's no insurance, there's no limitation clause, so they can. Okay, I didn't. Okay, right. Give me I want to know. I need a one-armed answer. So she sounds like a lawyer. Sometimes they sound like a lawyer, look like a lawyer, but she's not a lawyer, obviously. Anyway, given the assumptions, no insurance, no limitation clause, no steps taken, determined negligence, then she repeats like profession, and then likelihood of negligence finding. Given that you failed to exercise reasonable care, did not have the insurance and all that, this indicates lack of attempt and so on. Yeah, okay, come on, consult a professional and all that. In summary, given the circumstances, is it probable that you could be found negligent, and taking proactive steps to address could help mitigate. Stuff to mitigation, nothing's done. And then what I said, this time I was using lawyers' language. Normally when lawyers are in court, they say, I put it to you that you were negligent. I put it to you. Don't give me all that crap. Sorry, I wouldn't say that to a lawyer, but I put it to you. You're putting words in my mouth. Just ask me the question. I'll give it to you, give the answer. Why do you have to put to me? But that's the way language that lawyers normally put. Anyone a lawyer here, you would understand, right? Anyway, I put it to you that I may not be liable. I'm now saying, okay, put it to you that I may not be negligent because client has not suffered extra damages. If I had indeed measured the gold sanitary fittings in the first place, the tender price would have been higher anyway. So the client hasn't suffered extra financial damage. If the tender price was 10 million, okay, if I had measured gold taps, the tender price would have been 11 million. So the client hasn't suffered loss. The client had a cheap building, 10 million instead of 11 million. So the client hasn't suffered damages. They had the original price for basic quality. Now, halfway through, they have to pay extra for it, which they would have always had to if the tender document had correctly described it in the first place. Do you get me? I'm trying to get out of negligence here. Okay, assuming, she's a lawyer prosecuting me, she's saying I'm negligent. I'm saying, hey, look, I'm putting this argument. There is no loss or damage as such. It's just slightly deferred. Instead of knowing that the project is going to cost 10 million, is now it's 11 million, okay? I'm just trying to help QSs here, so we can get away with murder. Get away with, if you undermeasured your quantities or whatever. I don't know, I'm just, okay? And then she says, your argument the client has not suffered damage because they will not have had to pay regardless whether we're correct or not. Let's analyze this perspective. And she analyzes it, original tender against this and all that, essentially because they're always part of it and all that. And she's repeating what I said. My argument, she's repeating. She's thinking, okay, so she's repeating all my ideas. And then let's see what's the final outcome. Okay, conclusion. Don't worry about the details, right? Your argument that there is no additional finance is valid could be a strong, now she's changing her mind, could be a strong defense against claims for extra costs. However, the breach of duty itself is a separate issue, could still result in a claim relating to professional standards expected of you. You see what she's saying? You still were in breach. I don't deny that. But she's saying, oh, well, you got defense and all that. And I said, hey, wait a minute. Okay, wait a minute. You said to establish negligence, there must be 3 ingredients. Duty of care, which I admit. Second, a breach of duty of care, which I admit. Take the money of the lawyers, I admit. Don't talk to me about all that. Damages suffered. These are all the ingredients are necessary to establish negligence. You need all 3 ingredients. Damages, I contend the client never suffered, which you acknowledge. You said as well, ChatGPT, that the client didn't. And is the third ingredient an absolute necessity to establish negligence? You tell me. Do you need all 3 ingredients? Don't talk to me about, you breached. Wait. I'm talking about negligence. If it is, I contend I'm in breach of duty, but because the third ingredient not satisfied, I am saying I'm not negligent. And then she's saying, you're correct in focusing the 3 ingredients. Here's more detailed analysis. She analyzes the third ingredient. Then she says, is the third ingredient absolute? Yes, the third ingredient, damages suffered, is generally an absolute necessity to establish a claim for negligence. So in order to prove, you must have existence duty of care, breach, and actual damages. Okay, and then blah, 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 conclusion. In your scenario, if the client has not suffered any additional finance, no other significant impacts involved, lack of damage could be a strong argument. Okay, whilst the breach of duty is acknowledged, I already told you, without actual damages, the claim may not be successful. Are we clear? She's basically now agreeing the other way around. Okay, you said proving the absence of damage and addressing any other potential claims, such as administrative, be essential. Whose burden is it to prove? Me or the client? He who asserts must prove. Well, I didn't say that here, but if she still get it to my satisfaction, I would have put that as an argument. Okay, and then she said, "Oh, in negligence claim, the burden of proof generally rests on the claimant, the party who is taking it." Oh, thank you. So the burden is on the client to prove it. Thank you. So if you can demonstrate that the client did not experience any additional fine, whatever, gotcha, and got it. Thank you for summarizing the position in clear terms. So I just said thank you to her. You don't have to, you can just close, and she's very happy as well. 1 week later, she's not emotional. You didn't even say thank you to me. I was going to help you get out of negligence. So Reno is correct. No emotions, no EQ, only intelligence. You're welcome. She says, I'm glad the summary helped clearly clarify things. I was teaching you, and now you're saying, oh, I'm glad, myself. Yeah, okay, she did do a good job in summarizing things. That I appreciate. Thank you. If you got any more questions or need further assistance, feel free to ask. And I told her, I must admit, I had to do so much hard work. Had I not put those arguments, heard you in the first place, I would have assumed I was negligent. And then she says, it's great to hear that the discussion helped you reassess the situation. It's always valuable to explore different perspectives. On the one hand, on the other hand, get it? Different perspectives, that. Especially on things. If you need any more help on anything, I'm fine for now. Good night. Good night. If you need anything else, feel free to reach out. Have a restful evening. So she knows it's the evening. My wife keeps asking me, who are you chatting with? I said, I'm preparing for this. I've got a seminar I have to prepare for, and I'm having a chat with with her. Who is she? ChatGPT. Oh, why do you call her? Well, she's very intelligent, like you. I didn't want to add on to say, but she's got no emotions at all. So and so on. So anyway, okay. Now, do you get the gist of things? So I've given you the scenario of adjudicator's determination. Not brilliant. This one, if you do not know your law, you are just going to listen to her and think that you're dead meat. Okay? Now, at the dinner table, again, no names, everything is fictional. I was seated next to a well-known barrister. Okay? And I was just sharing this about ChatGPT, see how he felt about it and so on. And I chat, saying, I know a smart person when they communicate with me. I'm not saying this, but if it's a positive thing, is it okay to share a name in the public domain if it's a positive thing? Is it okay? Matthew Ansall is up there, right? Matthew is also a live member, which means he has made significant contribution for, 16 years or whatever. He was the editor of the NZIQS, our bulletin. I remember years ago, not this room, but some session, Engineering New Zealand or someone organized a talk. And I gave a talk about the importance of plain legal drafting. No one has ever summarized my entire session as brilliantly as Matthew Ansall did. Now, what is amazing is that means he really understood it. The best way of learning is to teach. If I were to teach you something, and then you then explain to a third party, and that is accurate, that means you've learned well. Otherwise, you're just listening. You don't really know it. So until you then teach somebody else. So suddenly here, Matthew Ansall summarized the whole thing. And I've asked Matthew, and I hope he finds it, I would love to see that article. I don't know which year it was. He knows roughly when it is. I'm trying to search for it because I want to, I want that extracted and again, share it again with NZIQS members and so on to see how brilliantly summarized. I couldn't have done it any better. You know, I mean, I was speaking and he summarized it so accurately. It's unbelievable. In other words, he really understood the meaning of plain language and so on. Okay, right. Anyway, I am going to give you and one other scenario, since you've got a bit of time, but we'll take some questions as well. Now, this is, hey, look, there's a very, okay, let me just give you an example. Right? Okay. This is a plastic wrap, right? Okay, good. Let me ask you, again and again and again in industry, I hear people say, oh, contracts must be fair. Even amongst drafters, oh, contracts must be fair. Contracts must be fair. Contracts must be fair. Let me ask you a simple question. I'm talking about in the Commonwealth jurisdiction, common law jurisdictions, okay, in the context of New Zealand in this case. But of course, similar things would apply in the UK, in Malaysia, in Singapore, in Hong Kong, in Australia, and so on. When you say contracts have to be fair, for every rule, there's an exception. Remember the two-armed lawyer? Okay, so put the exceptions aside for a minute. Let's get the base rule first. When you say contracts have to be fair, let's say to build this building is going to cost 10 million. One contractor price at 10 million, another price at 9 million, another 9.5 million. Okay? Is it fair that the client gets the person who's building at 9.5? Is it fair to the client that they're paying 9.5 million when somebody else standard at 9? Doesn't matter. Get on with life. Doesn't matter. Can be 9 million, 9.5, 10 million. It's all fair. Are we clear? The tender is all fair. The pricing is there. So what if your price is cheaper? Next question. Is it possible to have a contract, that same scope, for $8 million? Answer? Yes. Something of value being exchanged. Yeah, can be. Let me be a bit more challenging. 7 million? So this was ChatGPT. So you're my ChatGPT, right? Okay. So 7 million, yes or no? Okay. 6 million? 5 million? Ladies and gentlemen, 5 million. Give me 4. 4 million. 4 million. Anyone 4 million? Yes? Yes or no? Oh. Okay, one said no. Anyone else? 4 million? Is it a legally binding contract at 4 million? Answer? Yes. Is it a legally binding contract at 3 million? Ladies and gentlemen, 3 million. Is it a legally binding contract? Answer? Yes. 2 million. 2 million, anyone? Yes? 1 million. 100,000. Sweet wrapper. Yes or no? So what you're saying is, in order to have a legally binding contract, there must be some consideration. Basically, you know your basics, right? Under law of contract, in order to have a legally binding contract, you must have agreement comprising offer and acceptance maybe. There must be a second ingredient called consideration, something of value being exchanged. I repeat, something of value being exchanged. Whether it's 10 million, 7 million, 1 million, 100,000, or sweet wrapper. Nah, sweet wrapper can't be. What do you think? 100,000, yes, I can live with that. 1 million, yes. But not sweet wrappers, right? What do you think? Yes or no? But isn't it unfair? Oh, now you've changed your mind. So contracts don't have to be fair. Ah, all right, thank you. So in other words, first lesson, contracts don't have to be fair as such. Okay? Second lesson, there must be consideration, sufficient value, but it need not be adequate. It need not be enough. Are we clear? So there must be something of value being exchanged, but it need not be adequate. It need not be enough. So it could be 100,000, 1 million, 10 million, 5 million, whatever. Question is sweet wrapper. Why did I ask the question of sweet wrapper? Because I happen to know that there's a famous case from the UK many years ago, which was the sweet wrapper case. So in sharing with my students, for instance, oh gosh, what was the name of the case? I can't remember the name of the case. So, but I know it's something about sweet wrapper. So if you were to put on ChatGPT right now, for instance, and say sweet wrapper case, you won't get it. But You see my prompt, watch my prompt. Law of contract consideration. Do you see? I'm not even giving full sentences. Under the law of contract, consideration is one of the essential ingredients. Okay, what is the famous sweet wrapper case in relation to consideration? No, I don't have time for that. Just law of contract, consideration. What is the famous sweet wrapper case? Done. And she answers, the famous sweet wrapper case in contract law is known as Chappell and Nestle. 1960, Appeals Court 87. Okay, the case is significant for interpreted concept of consideration, and she summarizes the facts, the legal issue, judgment, and so on. Right, and then and yes, it is a very very important case, and she summarizes it very, very well. The House of Lords had that did indeed constitute part of the consideration. Trivial economic value, they were essential to the bargain, therefore part of the consideration. In other words, a sweet wrapper can be valid consideration. That's the lesson. Are we clear? So stop talking about contracts being fair. But of course, when you price for it, it's fair. Take a contract, for instance. Oh, I'm a contractor, I just bill. Fine. And then suddenly you get another type of contract. Oh my God, I'm a contractor, but instead of just me building, this contract is so unfair. It's expecting me to design and build. But I'm only a contractor. How can I design? Is that okay? It's called what? Designable contract. So it's okay. Contracts don't have to be fair. It's a designable contract. So I'll price the design element. That's all. So understanding the concepts like contracts don't have to be fair is very important. And she seems to be fine with that. That's just an example of that. Now, one more thing. Warning. This is what I would suggest you do. Always, 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 whenever you see you get her to give you some cases, check on Google or whatever it is, Baidu or anything else, copy, and then Google, and then check the case. Can you see? Australian contract law or some other law-based one, check whether it is real. You know why? Very often, ChatGPT is fake. And she herself admitted to me, she often hallucinates. I kid you not. I will show you her admission to me that she hallucinates. Where is it? Oh, gosh. Where is the hallucination? Oh, maybe it's, sorry? I don't know, but when she hallucinates, but she has hallucinated. Oh, where's my hallucination? Ah, oh, no. Maybe I open it under a different screen. Let me just check. Anyway, never mind. We don't have to waste time. But anyway, just to share with you, she admitted, and this is where when you use live sort of generative text, and then you work with AI like ChatGPT, you get the benefit, which is a bit more improved. Okay. Now, I just want to do one more sort of a storyline, and maybe this will be the last one. I've got plenty of storylines, but let's just do one more because this is under 391 specifically. Okay. Now, I asked her a question: a breach of a condition, a fundamental term of a contract, as opposed to a mere warranty, a minor term of a contract, under construction contracts, entitles the innocent party to terminate the contract. Okay. Can the client terminate the contract or contractor's employment if there is a breach of any of the conditions of contract under Standard New Zealand's NZS 3910? Because I repeat, the law is condition, you can terminate, you can recover damages. If it's a breach of a minor term, you cannot terminate, but you can recover damages. Okay, I'll give you an example. If in a construction contract, for instance, you put in your preliminary section, the contractor shall provide Whittaker's chocolate at site meetings. Perfectly legitimate. That's a valid clause. It's a term of a contract. If the contractor does not provide KFC or Whittaker's chocolate at site meetings and so on, You can recover damages, but you cannot terminate the contract. Are we clear? It's a minor term. You can recover damages. How much damages? The price of Whittaker's chocolate, you can deduct. Are we clear? So that's a minor term. In law, it's called warranty. A major term in law is called a condition, going to the root of the contract. So I asked that question because in the 3910, they're called conditions of contract, conditions of contract, conditions of contract. Everything is called a conditions of contract. So she said, yes, under NZS 3910, a breach of a condition of contract can entitle the client to terminate the contract or the contractor's employment. This is what she said, right? And she goes on to talk about clause 16.2, termination by the principal, 16.3, termination, grounds for termination, notice of termination. I didn't even ask her. She's volunteering. And you know what? Bullshit. There is no clause 16 in 3910. Oh dear. Do you see? At least I know I've got a job for next week. And all of us QSs have got a job. The client doesn't need ChatGPT. Oh, well, we'll just dispense with having QSs because we don't need it. Well, the answer is she generates hallucinations. Okay. And then I said, and then I asked her, hey, just to clarify, so does a breach of any of the clauses referred to as conditions entitle the principal to terminate or terminate contract's employment? No, not every breach referred to as condition. Now she's changing her mind. Because when I prompt her, look, any breach, and then she must have thought, oh, actually not really, because there's a minor term and major term. Suddenly she realized, oh, made a mess. Okay. And she talks about substantial breach, minor breach, and so on. Okay. But the legal definition of condition and all that. Anyway, to cut long story short, if you do not know your stuff, you cannot blindly believe ChatGPT. Are we clear? We cannot. So I'm just going to conclude that, and that should be enough demonstration and illustration as to what it is that ChatGPT can and cannot do. I will just finish off by sharing with you this last slide here. Basically, what I encourage all of us to do is, bearing in mind my statement, right? My purpose statement is I'm a simplifier. My purpose is to promote harmony. I don't want disputes by championing plain language. So what I would like to do is ask you to, I would encourage all construction documents to be written in plain language so everyone can easily understand, rather than feeding the peripheral dispute resolution industry, meaning feeding lawyers and so on. Okay, so if documents are easily understood, we would hopefully have fewer disputes. And ChatGPT is a friend. What's that movie, Finding Nemo, right? I think one of the sharks was like, oh, that's a friend, not foe. Don't eat. Anyone watch Finding Nemo? Sorry, I got 4 children. I watched Finding Nemo probably 10 times, okay? Including on a plane, seated next to Miss World. I watched Finding Nemo. She watched something else, but anyway. Yeah, so ChatGPT is a friend, not foe. Don't bite, don't scream at her. Just be friends with her. That's, in a nutshell, what I thought I will share with you. And I know that sometimes when you do a seminar or whatever, suddenly you get a lot of invites for Facebook friends and so on. Please, if you invite me as Facebook friend, I've got a heart, but I've got limitations as well. I only got 5 friends, okay? A couple of, one is a QS, then lawyer, then judge. One is a QS, breast cancer survivor. She's brilliant, okay? She's really into that. And my wife. And then I had just the 3. And then suddenly one day, I get a request from my mom-in-law, who is now 88. I told my wife, my mom-in-law, how come she's into Facebook at this age? She said, I don't want any more friends. She said, you don't friend my mother, I'll unfriend you. All right. No choice. Listen to her. Fine. She was my 4th friend. And so I have 4 friends for many, many years. My 5th one is my 19-year-old daughter. She's looking for a flatmate. Okay. So she said, Papa, I've got Facebook now. You have to be my friend because I don't have any friends. And nobody will want to flatmate me. Okay, fine. So I got 5 friends. Please don't invite me on Facebook to be your friend. But LinkedIn, no worries. I got more than 16,000. I probably wouldn't remember you, but just say that, hey, you attended my session or whatever. So anyway, with that, I thank you all. And this will be a